Tonight, we are marking the Kingston coal ash disaster. Today is 14 years since 1 billion gallons of coal ash broke out of a TVA holding cell.
They told us in a safety meeting that they could eat the ash and it wouldn't hurt you.
You just heard from Tommy Johnson, a former employee at the TVA Kingston fossil plant in Kingston, Tennessee. Tommy and many other workers inhaled coal ash. This presentation seeks to put their experiences in a broader discussion of the complicated story of the Kingston fossil plant spill and subsequent cleanup efforts. This deals with a confluence of federal statutes and agencies, as well as actions at both the local and state level. This is a story about environmental justice and the failure of existing mechanisms of environmental remediation and compensatory damages for victims. This includes the stories of the workers adversely impacted while doing remediative work, those whose houses were destroyed by the spill, and the residents of Uniontown, Alabama, where the coal ash was sent after it was dredged up. An important background to the Kingston story is the chemical composition of coal ash. Whilst coal has since been phased out, the preeminent form of electricity generation in 2008 was coal at 48.2%. Coal ash is the byproduct of burning coal. Despite not being classified as a hazardous waste by the EPA, there is a confluence of toxic chemicals in fly ash, including but not limited to mercury, arsenic, and copper. That poses challenges of both environmental and human health significance. These toxic elements can cause cancers, asthma, and leukemia, as well as effects on the environment, as these elements bioaccumulate up the food chain. The children of residents near Kosh had a 1.85 times more likelihood to have more allergies and a 3.1 times likelihood to have stomach issues. However, the health effects of coal ash and its impacts are systemically under-researched, and most of the information comes from, quote, survey-based research. The available studies are based on animal models and in vitro experiments. Coal ash is stored on site and in close proximity to water sources, which is a really good idea. The majority of coal ash is held in surface impoundments and landfills. Whoever made this graphic is awesome. It shows the link chain between surface impoundments and water sources. This is not dissimilar from the process at the Kingston facility. This is a schematic of the Kingston fossil plant facility that is the subject of this presentation. The coal ash was held in a retaining pond, which failed and collapsed, which percolated around the Emery River and downstream effects on the Clinch River. On impact, it destroyed homes. 4.1 million cubic meters of coal ash cascaded to the Emery River, and the surrounding neighborhood was upended completely. There are two principal legislations to provide compensation and recovery for both the residents of Kingston and the environment surrounding the spill. The first of which is CERCLA, the Comprehensive Environmental Response Compensation and Liability Act. This statute, enacted in 1980, was invoked immediately following the spill. It is designed to give the executive, mainly the EPA, flexibility in responding to large environmental cleanup projects. It gives the EPA two pathways of remediation. Either they can compel, under threat of strict financial penalties, responsible parties to assuage the human and environmental impacts of the disaster, or they can take primary responsibility, which occurred in the context of Kingston. Embedded in this is the power to classify coal ash as a hazardous material, which is not the case under the authority of the EPA. The remediation was outsourced to a remediation company called Jacobs Engineering, who you'll unfortunately hear about soon. The second piece of legislation is the Federal Tort Claims Act. This is the primary statute invoked by the workers and homeowners. It gives the power to sue the federal government as they are liable, quote, to the same extent, end quote, as a private individual. The caveat that was the subject of controversy in this case was whether or not the TVA's negligence was the subject to the discretionary function exemption, which essentially dictates that if it's in their official capacity, they're exempted from lawsuit. Why that failed in the context of the Kingston coal ash bill will be further explained below. Missing from this project is the Clean Water Act and the Resource Conservation and Recovery Act. Both of these statutes can do little post-spill, and it does little to help victims pursuing damage claims against the government. It was rules as explicitly precluding private action lawsuits. Whilst the CWA and corresponding statutes are implicated, this is a story about remediation, not prevention. It is a presentation of what should have been done in the aftermath of the spill. The Kingston Coash Bill adversely impacted the lives of three discrete groups whose stories I endeavor to share in this presentation. The first group is the homeowners in the surrounding area. The Coash spill made their homes destroyed or inhospitable. They were approached immediately after by the TVA and given an offer for their homes. This was done in exchange for not joining a lawsuit. 800 people did not listen to that and pursued remedies in district court in Tennessee. They sued the TVA under the aforementioned Tort Law Act. A pertinent issue raised in the case was the discretionary function doctrine, which posits that if it's in their official capacity, they are not held liable, even if there are damages. However, the court disagreed with the TVA's legal analysis. Their negligence in this case was not in their official capacity, and thus the lawsuit continued, and the plaintiff's motion for damages was granted. The court ruled on many issues of negligence, including the TVA failing to inform and train its staff of the risks involved with the coal ash ponds and the construction itself being improperly constructed. This was a very complicated case. There were over 900 filings and more than 800 individual plaintiffs. All of this was not consolidated into a class action lawsuit. Look how confusing this overview of the case is. After this ruling, there was a settlement between the TVA and the homeowners for approximately $27.8 million for damages to their home and well being. However, these damages, of course, do not fully account for the emotional impact of losing your home, your possessions, and the place you call home. This is the Emery River today, which sharply contrasts with the visuals early in the presentation. This is, however, not a happy end to the story. Authority was given to the Jacobs Engineering Company to clean up the river and remediate environmental damages. However, the workers who took the job due to the high unemployment rate generated by the 2008 financial crash were not trained of the risks involved. They worked close to 14-hour shifts and were not given sufficient protective gear. As you heard in the beginning of the presentation, they were even told that they could, quote, eat coal ash. The following is a description of the experiences of the workers. Quote, some workers started blacking out in their cars, having nosebleeds, and started coughing up black mucus. It became clear to them that coal ash was the cause. Many workers died in later years due to diseases that were ascertained to have come from coal ash. A horrifying example is of a safety manager destroying masks at the facility which were requested for by workers. The workers appealed to the Occupational Safety and Health Administration and alerted them of the conditions in which they were working. However, the Occupational Safety and Health Administration proffered that the Jacobs Engineering Company should self regulate. However, they did not change anything, and subsequently, the workers filed a lawsuit, this time against the Jacobs Engineering Company, rather than the TVA. Reading about this lawsuit was quite troubling. The strategy of the Jacobs Engineering Company was to drag out the case as long as possible. Look at the timeline of the case being appealed and sent back. The overall lawsuit was resolved in 2023, which took about 10 years to conclude. Even then, it wasn't sufficient compensation. Many of them were struggling to pay medical bills and settled with at least an amount of compensatory damages. Jacobs proffered that they had derivative immunity pursuant to the discretionary function exemption, which did not stand in the Sixth Circuit Court of Appeals. You might be wondering, where does 4.1 million cubic yards of coal ash go when it's dredged up from the Emery River? The answer to that question is Uniontown, Alabama. The Alabama Department of Energy Management and the TVA, with consent from the EPA, made an agreement to send the coal ash to the Arrowhead landfill in Uniontown. Demographically, Uniontown is 90% black and has a per capita impact of less than $10,000. As described earlier, coal ash is a hazardous substance. It causes health impacts and is especially harmful to children. However, Uniontown became a dumping ground for the waste generated by the spill. Coincidentally, it was described as a quote non-hazardous substance when it was sent to Uniontown under the Comprehensive Environmental Response Compensation and Liability Act. The community in Uniontown made efforts to the Alabama Department of Management and other relevant agencies in Alabama. When these efforts failed, they issued a direct appeal to the Environmental Protection Agency's Civil Rights Division. They alleged discrimination in the effect of the transfer and made a confluence of health and wellness claims, including but not limited to dizziness, nausea, vomiting, and excessive dust on their property due to the nearby facility. However, the EPA did not provide relief. They denied the claim, as they do with all other claims. They earned a sharp rebuke by the United States Civil Rights Commission, who wrote in a report that the EPA had, quote, never made a formal finding of discrimination. Despite the EPA having information that low-income communities are, quote, more likely to live near coal ash disposal sites, there was not remediation, and the coal ash is continuously there. Unfortunately, court remedies were not available for private action as it pertained to Title VI and environmental racism protections. Alexander v. Sandoval, which was decided by the United States Supreme Court, quote, closed the door on, quote, private right of action as it pertains to disparate impact regulation. They did find themselves in court, however, when the already impoverished community were sued in defamation for $30 million due to Facebook posts alleged to be false. They were represented by the American Civil Liberties Union, and the defamation lawsuit was dropped. This, however, is a microcosm of the power imbalance in the structure. Despite efforts by the Uniontown community, the structural disparities make the lawsuit life-altering for one side of the courtroom and another day in court for the other side. This is reflective of the imbalances in environmental justice and even environmental remediation. To fight back, Uniontown residents created the Black Belt Citizens for Health and Justice, which is concerned with the environmental and social well-being of Uniontown. Esther Calhoun, the president of the Black Belt Citizens for Health and Justice, appeared before the United States Commission on Civil Rights. She reached out directly to the Environmental Protection Agency and advocated for her community to, quote, keep coal ash out of her community. The Uniontown component of the coal ash spill in Kingston is comparatively less well known. There is less scholarly literature, and it was difficult to find information of the people that were affected. As one scholar writes, quote, why are there not more scholars writing about this? Why is it that the majority of Uniontown's pollution problems only exist in articles? End quote. In totality, the process you have seen in this presentation was needlessly complex and glacially slow. You can see the clear power imbalance in these cases between the workers and a company that has the capacity to drag out litigation for 10 years until the plaintiffs are forced to accept terms that don't remediate the damages. I do not believe the Kingston coal ash spill to be lost in history. I believe it to be an instructive account of the failures of environmental justice standards at the federal government level, and there is reason to believe that a spill of its kind might happen again. There are two reasons why this is likely. First is climate change. The potential impact of climate change on coal ash impoundments are both a concern and systemically understudied. Climate change has a litany of conditions and effects, which include the potential for flooding and, quote, mineral weathering. Both of these are a major test of the adaptability of coal ash structures, and there's a likelihood of structural failure and flooding. The structures of coal ash facilities are not new or adaptable to rising temperatures and the risk of flooding and rain. Additionally, in 2014, the EPA estimated that 152 coal ash impoundments had, quote, poor dam integrity, which, when combined with the threat of weathering as an effect of climate change, makes it an increased likelihood that another event could happen. This is compounded by the Dan River coal ash spill, which was a separate spill that happened in North Carolina. Second is Trump. Trump's EPA is committed in large to deregulation as being the forefront of his policy agenda. The EPA have essentially punted the issue down the road. They want to, quote, extend the deadline of facility evaluation reports. They, quote, propose to, quote, extend the deadline of groundwater weathering until 2029. There's a magnifier of risk posed by climate change, and the current administration is not focused on preventing it, despite the catastrophic nature of the Kingston coal ash spill. Lastly, environmental justice. It is certainly not at the forefront of the EPA's policy position, and there's evidence that a majority of coal ash impoundments are close to low-income communities. However, there are not levers by which the communities can fight back, due to the restrictions by conflicts of federal statutes and agency regulations barring private action lawsuits. Regulations such as Title VI of the Civil Rights Act and the Clean Water Act ought to have mechanisms by which the citizens can directly file lawsuits, which are addressed in a timely manner. However, this is also an issue of economic inequality. Lawsuits are expensive and time consuming. At the forefront of environmental policy ought to be equity. The Kingston coal ash spill is a microcosm of environmental injustice and the risks of lackluster and patchwork regulation.